Okay, our last case this morning is case number 18-912, Mary Jean Ann Williams versus Riverbend of Cocoa Beach, Inc., Riverbend Condominium Associations of BREVARD, Inc., etc. Okay. All right, good morning,
Good
counsel.
morning, Richard Taylor. I'm with the firm of Taylor and Nordman and DeLand, and I represent Mary Jean Ann Williams.
Go ahead.
May it please the court.
Yes, sir.
The prime issue in this appeal is that the lower court completely disregarded the well-settled survey law that had been developed in the state of Florida. We have also raised points on appeal with regard to flooding. The two properties are adjacent to each other, and in the course of the development of the condominium property, it was raised up about 4.5 to 4.7 feet, and this has created flooding issues on the lower property, which is the Williams property adjacent. Also the condominium property is hardened property with very little permeable surface left, and the Williams property is very permeable. And there are aerial photographs that show how much open land she has on her place as compared to theirs. We also raised points with regard to some very confusing things in the lower court's judgment. The lower court entered a written judgment which basically conflicts with the oral pronouncements that it made, and many things that are included in the oral pronouncement are not included in the written judgment. And even more bizarre, the written judgment includes and finds that the line is by a survey that wasn't even in existence, or drawing that wasn't even in existence at the time of the trial. And
Did you know that the judge had asked for that survey to be prepared post-trial?
no, sir.
So how did it get prepared?
I presume the condominium folks had it prepared and submitted it to the court. I don't know.
Were you provided with some copy of it when it was submitted contemporaneously to the judge for
I
consideration?
believe I was given a copy of the proposed judgment, yes.
So you had a trial, and then whatever period of time later, all of a sudden there's another survey that comes in that you received?
There was a trial. The trial concluded. The court called us all back together, gave a bunch of written pronouncements.
Oral pronouncements,
Oral pronouncements. And then at some point after that, I believe, was when the document was created.
Well, what, did the judge at the oral pronouncement hearing ask for another survey to be prepared?
Not that I recall.
So a survey, just your opponents and their surveyor took it upon themselves saying, now that we heard the judge say things, we're going to do another survey and send it many weeks post-trial for the judge to look at? That's what you seem to be telling us. That's what you're saying.
That's as far as I know, I guess that's what happened, yes.
And when the survey was sent to the judge post-trial, you got a copy of the survey?
I don't remember whether I got it before the written judgment, or I think it came with the written judgment, yes, sir.
Okay, so the first time you become aware of the new survey was when there's the final judgments actually entered, and you file a motion for rehearing saying, my goodness, how could this possibly be that we have a survey not based upon any evidence presented at the trial that's now controlling in some aspect of the final judgment?
Well, at that point, we knew we were going to appeal anyway, so as to the court's oral pronouncements as to survey, and so we just let the court do what the court was going to do, and Figure we address it.
So your
on appeal.
answer is no to my question. You didn't
Yes.
file a rehearing and say, Judge,
No, sir.
you know, might not like some of your other rulings, but you certainly can't base your judgment about evidence that's not really evidence or a survey that's not evidence. You didn't bring that to the judge's attention.
No, sir.
Okay. All right, go ahead.
I mean, the whole fight here is whose survey was accurate in terms of establishing that section line that's the boundary in dispute, correct? Well, I mean, in terms of the
Here's the way I put
property
it, Your
line.
Honor, is that there was only one survey. The survey is what is done on the ground. And the only.
Well, okay, I'm going to get to that.
Yes,
But
sir.
it's a dispute over which surveyor got it right.
Yes, sir.
And according to Florida law, as you've laid it out, it's what's on the ground controls.
Yes, sir.
Okay. And Mr. Salmon essentially relied on Mr. Wilson's survey from 1946 that created the plat of Orlando Beach, correct?
Yes, sir.
And how are we sure that Mr. Wilson got it right when he laid out that section line as the north boundary of Orlando Beach?
Well, after the original government surveyor, that is the only evidence of any monumentation on that line. And Wilson also incorporated two State Road Department monuments that existed before his survey.
I understand that, but, you know, again, how do we know the DOT got it right?
Well, there is no other discussion by any surveyor as to any other monumentation. The Mr. Putz, who did the survey for the Condo Association, didn't even look for lost or obliterated, or didn't make any decision as to the
No, I
type of
understand.
corners.
Trust me, I understand the difference in the way the surveys were performed.
Yes, sir.
Tell me this, how did Mr. Salmon find the northwest corner of the property?
He surveyed the entire line.
I mean, what did he do? Did he come from the Naval Monument down south, meander the river however many feet and say, this is it?
He had previously found some of the monuments that he said were perpetuation of the section line as shown by Wilson. Remember, Wilson was in 46.
I understand. So which monument did he come from to get to that northwest?
Well, he ran the whole north line based upon the Wilson monumentation. And then he tied it in by running back down to the south part, which is the Banana River Patrick Air Force Base, and there are substantial monumentation across that. It all tied in. He also ran it up north.
That's
into
why
Crescent
I'm really
Beach.
concerned about, how did he find that northwest corner? From where to where did he run?
I don't know that he ran from any particular. He found points and confirmed obliterated corners on the north line. That creates the line. And then,
Are you saying he found monuments in the northwest corner that he relied on?
no, sir. No, sir.
All right, where did he find the monuments that he relied on?
He previously found one of the PRMs, which is a state road monument in the,
It was on the east side,
y-
along A1A, wasn't it?
yes, sir, it was along A1A, and I think it was I think he found one on the east side and found perpetuation of one on the west side where the Nielsen Monument, I think, was, that he ran through.
Nielsen Monument on the northwest corner?
At the northeast corner of the,
but-
southeast of the condo, northeast of the Williams property.
Right, so that's from the northeast. That's the northeast corner. Does he then find the northwest corner by a run over to the northwest?
I guess you could call it that, down the line, up and down the line.
Well, right, but how did, again, this is where we get to the difference between Salmon says, yes, it says east, but back in the day, actually getting a true 90-degree east was unlikely to happen, whereas the surveyors for the condominium say, east means east, that's 90 degrees, off you go. We came to this point and went east, and we're a couple of feet different on our northwest corner, essentially, than what Mr. Salmon is. And that's why I keep trying to figure out, how did Salmon come up with that northwest corner? We know, there was confusing testimony about whether he did or didn't rely on the return of the seawall. I think after going back and forth 2 or 3 times, his final answer was he didn't. It was confirmatory.
Yes, sir.
but it's really unclear to me how he wound up with the northwest corner. If you knew, or he could say, this is the northwest corner, here's the northeast corner, then you could tell what the compass direction is between those, and you could understand then why you would say, well, it's not a true 90-degree angle, it's not a true 90-degree compass bearing, because you go from northwest to northeast, and it's just slightly off a little bit. But if you don't know how he got to northwest, how is that a justifiable?
He got to the northwest by running the section line in its entirety from east to west, and that's where it terminated.
Okay, but he ran an 89-degree angle rather than a 90-degree angle. With what justification?
He ran the section line and found that it had that angle. And again, angles are relative to something else. For example,
That's what I'm trying to find out.
okay. For example, the 90 degree that Putz used in his drawing. Now, mind you, he didn't survey it; he just drew it.
I know.
He uses a different bearing for the state road, which would bring a different bearing on the south line as he drew it. If you go, what he was trying to do, and he clearly says, he was following something that Campbell and Van Leer did in 80, he doesn't know when, 85. It's a drawing, has no legal description on it. The only thing it does indicate that they found a line up in Crescent Beach, and they ran 330, which is what the plat of Crescent Beach called for, and they said, okay, well, here's how the section line is established, by running it off a non-government corner, or line which has not been perpetuated in any way, shape, or form. But you will note on that drawing, it's not straight east-west on the drawing that he was attempting to follow.
I guess where does Salmon then come up with the 89 degrees? I know it's in change with minutes and maybe seconds or not, but where does he get to that angle from?
He ran the line. The line does not dictate the angle. The line does dictate the angle. The angle doesn't dictate the line.
Right, and I'm talking about the ground. Where on the ground did he go? I'm coming from here to here, and this is where I get 89 degrees and change of an angle heading towards the Banana River. Therefore, if you go from the northeast corner to the northwest corner, this is the property line. This is the section line.
The angle that he follows I believe he follows the angle of the state road off of the plat of Orlando Beach, which is different than what Mr. Putz's drawing showed for the angle of the state road. That right there would explain any differences in the angles. So like I say, the line determines the angle, not the angle, the line. He didn't come to a point and say, I'm going to go 89, whatever here. He ran the line and then correlates that bearing to the bearing on the state road, and that state road bearing is different than what was used in the Putz drawing.
So basically, you're asking us to say, you're asking that we reverse the judge, direct that the judge enter a new judgment that basically uses Mr. Salmon's survey to set the boundary line.
Yes, sir.
Okay, and there's how much difference in encroachment is it between the Salmon and the Putz survey?
Again, Putz was simply following Van Leer and Campbell.
I get all that.
So basically, Van Leer and Campbell drawing moves things to the south about 2 feet, I think, down by the water. And you look at the later drawing by Mercer, and you can see that the seawall return up on the north side of the condo property then ends up on somebody else's property because of the
So if the opinion says, okay, trial judge, use the salmon line, for lack of a better term.
Yes, sir.
And that now becomes the correct property line between the parties.
Yes, sir.
All right. So how does that affect, if at all, the judge's determination vis-a-vis the flooding damages or lack thereof?
Well, we addressed those points slightly separately, but one of the great things is the wall. And I realize talking about walls in today's world is controversial, but this one is a pretty substantial wall that basically has been put so close to her back door that when you open the door, you're almost face to face in the wall. There's plenty of photographic evidence to show the effect of the wall. So basically, and it would allow her to use the full 50 feet of her property, which she now cannot do because the wall encroaches and the footer encroaches. Everybody agrees the footer encroaches.
Right, the foot, but I mean, so part of the wall would be within this 2 foot of encroached property, is what you're saying?
Yes, sir. On the Salmon survey, he locates the wall in relation to the true boundary line.
So Riverbend's wall is, according to Mr. Salmon and his survey, is presently in part on your client's property.
Yes, sir.
And you would like to have that rectified because
Yes, sir.
she don't want to have somebody else's wall on her property.
Yes, sir.
And it's on the property in excess of 2 feet, correct?
Yes, sir. And
How far does it run, 2 feet?
it varies. When you look at the construction of the wall, they apparently started heading west, and then, the testimony shows she came out and says, hey, y'all look like you're getting close here, stay off my property.
So they put up a wall on what they thought was the property line, and your client says,
I cannot say what they were following when they put the wall up, but they did jog over to the north towards the condo property. I can't remember, about 50, 70 feet into the wall. There's a jog to the north, but then they followed an angle that brought it back down in a greater amount on her property at the western end.
okay.
So
Okay, you are into your rebuttal time. You can continue on if you want, or you could stop, however you want to do it.
I think I better.
It's up to you. It's your call. It's
That's
not.
all right. I'll save it for rebuttal.
Okay, very well. Thank you, sir.
May it please the court.
Yes, sir.
James Olson on behalf of one of the appellees, Riverbend Condominium Association of Brevard, Inc. Along with me is Joe Caruso. He is the attorney for the developer. I would like to reserve at least 5 minutes or whatever time, whichever is greater, for Mr. Caruso to speak.
Of your 20 minutes. Oh, okay.
Yes,
Yeah,
of
that's
my-
fine.
of
However
my
y'all
20.
want to use your 20 minutes. I mean, I don't think there was a cross appeal.
Well, the yellow light will come on for his 5 minutes, right?
Right.
Yeah.
Anyway, this case is a simple boundary dispute, and it's been made too complicated, quite frankly. No one is saying that if the 1857 survey, if that mango tree still existed, we would know where the boundary line is. If the 1940s concrete monuments placed by the developer of Orlando Beach still existed, we would know where the property line is. They do not exist anymore. And as Mr. Salmon testified, it's now the opinion of the surveyors. And we're all old enough here to recall when we learned math, 1 + 1 was 2, 2 +, we memorized it. 3 + 3 is 6. We memorized that. Now with new math, I don't know if any of you have younger kids, new math, 2 + 2 doesn't equal 4 unless you show your work. Their entire argument is Mr. Salmon's the only one who showed his work. Therefore, his is the only survey you can trust. That would be great if he found the monuments from Orlando Beach. He did not. He testified he found one at some point in time that he didn't even find when he went out and did his dependent survey.
So following up what Judge Edwards was talking with your opponent, so if he had found the northwest corner monument, Mr. Salmon, and walked it and did the
Right.
survey, then you would be sitting here with a problem vis-a-vis the
Correct.
accuracy of your survey.
Correct.
Your Mr. Putz's
In
survey.
the northeast corner of Miss Williams' lot, the parties are relatively within inches in agreement. This is the spot. And if you go from that and say, okay, where does it go to the Indian River to the west? That is the dispute. In the 1850s.
Right, whether it's 90 degrees or the 89 and change, right?
Correct. In the 18.
Let me ask you, and maybe you can answer, maybe you can't. Do you know how Salmon came up with his 89 degree and how he actually located that northwest
I
corner?
know exactly how he engineered a result. We know where it starts in the northeast. He said, I placed the line between the seawall returns. So if you start in the northwest corner and you put it in the seawall, then you're running 89 degrees and change.
Right, but then and it's certainly far from clear, because it seems like Salmon goes back and forth about what value he placed on the return of the seawall. His final answer was, that was confirming to me where the northwest corner was, but that's not how I got to the northwest corner. My question is, are you aware of testimony that does say how he got to that northwest corner apart from the seawall?
No, sir, I'm not aware.
Okay. I just wondered if I was missing something there.
No,
so.
I don't know how there was never any testimony by anyone who built the seawalls that we put it there because that was a property line, or we built it based on a survey or whatever. The problem is there were just no longer any monuments.
What efforts did your surveyors make to locate any monuments or to come up with some kind of a firm starting place?
If you read the legal description for the condominium, it starts at the northeast corner of her lot.
Right.
Then runs north, then runs west, then runs south. And it's that line that runs 90 degrees according to our survey. When you come south, there was
So then, in other words, for your surveyor's starting point, they were looking for the northeast corner of Ms. Williams' lot.
Yes, ma'am, or yes, sir.
And what did they do to find that? Did they just go out and look for the stakes that they thought Mercer had left, or?
Yes, basically.
And how do we know that Mercer found the right northeast corner? Or Van Leer, or any of the other predecessors that Judge Roberts refers to as the historical surveys?
I don't disagree with you, but it's that corner that seems to be, of all of the disputes in this case, that seems to be the least disputed issue of fact. That corner, as I stated at trial, within inches of where everyone agrees that corner is. There was the Van Leer, or excuse me, there was the Mercer stake. There was the
Possible
DOT.
Nielsen stake too, right?
Yes.
Yeah.
So that corner is really not highly in dispute. It's down by the river. And to get into your question earlier about the northwest corner, this is a large, long piece of property, about 300 feet. I'm just using round numbers. You change that line even a degree, and suddenly you have now created an encroachment where none may otherwise exist. Also, they're arguing, well, there shouldn't have been this survey as part of the judgment.
Why not?
Well, there had to be, quite frankly. The judge ruled, in essence, Mr. Putt's line controls. That's the line I'm going to find. There were no monuments on that line. So he had to go out and put monuments at each end and say, okay, this is the line that I found as the Judge Edwards found, that now monuments it for future generations. Otherwise, we still don't know where that western corner is.
But how did that post-trial survey come into existence? I mean, it's unusual for there to be a survey and evidence, if you will, post-trial.
I disagree with the concept that it is a survey. It is not a survey from the standpoint that he went out and changed anything he had previously testified to. What it was a monumentation survey. He put monuments in the ground that we can look at 20, 30, 50 years from now and say, okay, Judge Edwards ruled in 2018, this is the line. And now everyone can tell that when they go and start their surveys.
What were the monument survey then, were the parties given the opportunity, either party given the opportunity to question whoever it was that put together the monument survey prior to it being included as part of the final judgment?
Yes, sir. I drafted the final judgment. It was provided to Mr. Taylor well in advance. The copy of the survey was provided well in advance. And at some point, I had to say, okay, are you going to comment? Are you going to provide me a response? And the response was no, send it in. So I sent it in. And
How did Mr. Putz, what generated Mr. Putz to do this,
I
your
asked
monument survey? I mean, so,
I believe, and if I'm wrong, please correct me, but I believed a judicial finding that this is the property line makes no sense for future generations unless there are monuments there to tell them.
well, I know, but how it's presented to us by Mr. Taylor is, okay, all the evidence is in, the judge takes it under advisement, all of a sudden there's this new document that's created by Mr. Putz, and listening to Mr. Taylor for reasons that are not clear at all to him why Mr. Putz is out there doing it after the fact. That document's created, that document's sent to the judge, it's not evidence, but it then gets incorporated into the final judgment like it's some kind of, obviously persuasive evidence to the judge, and that's, that raises due process concerns, saying, you have to base your judgment on evidence.
I understand your concerns, but I think it goes both ways. If the judge had found in their favor based upon Mr. Salmon's line, Mr. Salmon's would have had to gone out and put a monument or, an iron rod or whatever in the ground to say, these are the property lines.
But after the judgment, I mean, basically what we're hearing, or at least what I'm hearing here, is that, okay, before the judge, has the judge decided who won at the time that Mr. Salmon goes out and does his monument survey?
Yes.
He'd already said, okay, I now agree that Mr. Salmon's survey is or Mr. Putz's survey, Mr. Putz's survey is the accurate survey, and so based upon that oral pronouncement, then Mr. Putz goes out and does a monument survey, and actually puts the monuments consistent with what the judge orally pronounced to be his ruling.
Yes, sir.
And then he created a document that was then submitted to the court for inclusion in the court file, for lack of a better term?
As I was drafting the order, which I was requested to do by the judge, it became at least my belief, hopefully I wasn't wrong, that's one of the things you will tell us, it became my belief that there were no monuments on either corner from either testimony from Mr. Salmon. Nobody put new monuments in the ground when they ran their surveys. So we needed actual monuments in the ground if the judge is going to say this is a property line, that property line has to be designated somehow in the ground for future surveyors and future generations.
Or else we're just going to have round 2 and round 3 of this whole thing.
Yes, sir.
Let me ask you this. The judge made certain oral pronouncements that did not reach the final judgment. Why? I mean, how can we let that stand?
I am not aware that there were anything relevant that Judge Edwards ruled that are not in his
Judge
oral
Roberts.
or Judge Roberts, excuse me, that there was anything relevant in the order that he
I think
did
the
not.
don't tear down the seawall was an oral pronouncement, because under Putt's survey, her seawall encroaches on your client's property.
Right.
And he said, don't you guys tear it down and leave it alone. Also, if the wall does fall down, the property line wall falls down, you guys need to move it over a little bit. I mean, those were pronounced. They don't make it to the written judgment.
If they're not in there and they're necessary and proper, I mean, keep in mind of this stretch of property, about the last 30 feet or so is state-owned submerged lands. It's now high and dry because of the seawalls. So we don't own the seawall, we don't own the land holding up the seawall, nor does Miss Williams. So it's state property, we wouldn't go on there to remove it anyway. We had no intention of removing any part of the existing seawall that we benefit from too, because it's holding back the river.
Let me ask you this other question. Everybody agrees that the footer encroaches a little bit into Ms. Williams' property at some points.
Yes.
I don't care how much or how long it is. Judge Roberts said that the remedy for Ms. Williams was to disclose the encroachment and get title insurance. How is that a benefit to her, or how is that a remedy for her at all?
I think Judge Roberts' ruling was that the encroachment is de minimis compared to the cost for
I
replacement
understand that,
of
but
the
he
wall.
said the remedy for her, for that encroachment, for her, is to disclose it if she sells it and to get title insurance. Well, how is that a benefit to her at all? How does that help her at all? She may have a legal obligation to make a disclosure, and I have no idea whether title insurance would somehow cover a known encroachment, but how is that a benefit or a remedy to her at all?
I don't know that it does. Certainly the wall benefits because the wall's required by code because it separates multifamily from single family. So she benefits from that wall. Now, the encroachment, yeah, I'm sorry, it encroaches. There's no disagreement. We can't deny that. The question is, how much does it encroach? And the testimony was inches, underground 2 inches.
If Judge Roberts announces, both orally and in writing, that he doesn't really see much water coming from River Bend over onto Williams' property, but I guess he sees enough where patch the wall up. There's cracks, patch it up, caulk it up, this, that, and the other. How is it consistent that there's no water flowing over, yet River Bend needs to patch things up? Confusing to me.
Yeah, well, there was also confusion as to the testimony where that water come from. Was it coming through the wall like Ms. Williams testified, or was it coming around the wall from A1A as there was other testimony? So I think Judge Roberts was, hey, look, if it's cracked, Judge Roberts did us a great trial. 4 days, gave us all the time we needed to put on a case. He did a view of the property. He went out there and looked at the wall. He walked both sides of the wall.
Let me just interject. You're into your colleague's
Yes, sir.
time.
I'd like to, if I may.
We'll let you pass the baton to Mr. Caruso.
Okay. And I'd like to stand on my brief otherwise. Thank you, Your Honor.
All right, thank you. All right, the clock says 4:13, Mr. Caruso. We'll give you an extra minute, and I'll give Mr. Taylor an extra minute in rebuttal.
May it please the court, my name is Joe T. Caruso. I represent the co-defendant, River Bend of Cocoa Beach, Inc., who was the developer of this condominium complex. My client developed this condominium complex with all of the governmental permitting agencies that required site plans, architect plans, drainage plans, and everything else. The governmental agencies told us where to build it, how to build it, how high it had to be, and what it had to consist of. Mr. Ringdahl built it just in accordance with all of the permits.
And of course, the government is never wrong.
That's what they tell us, Your Honor.
Well, but that, and that's a problem with that. I understand your argument that complying with all the government regulations and permitting and everything else is certainly evidence of reasonable behavior and doing things properly. It doesn't necessarily prove that following those regulations prevents flooding onto her property.
No, it doesn't. But the evidence before the court was, and the turnover took place in 2004. My client turned it over to the association and had no further involvement. My client had no idea what took place after 2004, and he wasn't involved in it in any way. So if
It
there
wasn't
wasn't...
filed till 2007, I think, is that right?
I'm sorry?
The lawsuit wasn't filed till 2007,
That's correct, Your Honor.
and the dispute may have started, obviously, somewhere between the time y'all started building it and 2007.
I think that's logical.
But do we know when, was there ever a dispute voiced to the developer about water flow?
The evidence before the court is that Mr. Ringdahl did not find out anything about the water on the property or water flooding until after the lawsuit was filed in 2007. That was the evidence before the court. And based upon that, the court made specific findings as it relates to the developer. The court found on page 6 of the final judgment, paragraph L, the court finds that the subterranean encroachment of association's boundary wall, more particularly the foundation of the boundary wall, onto and into plaintiff's property, to be de minimis non curat lex, which neither substantially nor materially affects the value or use of the plaintiff's land. So he says, okay, there is some encroachment, but it's not much, and it doesn't affect her ownership of the land, use of the land, and it has nothing to do with the flooding problem that the parties were arguing about. And then on page 8 of the final judgment, it says, the plaintiff presented insufficient evidence of lateral subterranean movement of water to overcome the presumption that the association's water retention system was properly designed and constructed and is properly functioning. And then...
That presumption was based on following the government regulations and permitting process, right?
No, I think that the presumption is that the association had built a berm that would prohibit or deter the water from going on Mrs. Williams' property. And with regard to the claim for damages, the
Where
court...
does this presumption arise from? I mean, somebody builds something that's not presumed correct. Why did the judge presume it was correct? Why was this presumption there that Ms. Williams had to overcome? Where did it come from?
I think the judge was saying that, you know, there's no evidence that the wall as built has anything to do with the flooding. The flooding is the result of the water coming off of A1A or the slope of Mrs.
He
Williams.
talks about this presumption that he's making, that Ms. Williams did not overcome the presumption that Riverbend had properly dealt with its water. Where does the presumption come from that Riverbend was properly dealing with its water? What's the source of that presumption?
I can't answer that question.
Or then why did she have to overcome something that we don't know where it came from?
I guess we'd have to ask Judge Roberts, because he certainly didn't delineate it any further.
All right.
But he did find that he says, the court previously found the subterranean encroachment of association property wall, particularly the foundation, onto the plaintiff's land to be de minimis non curat lex, which neither substantially nor materially affects the value and the use of the plaintiff's real property. Therefore, the court declines to award plaintiff any monetary damages for the de minimis subterranean encroachment of the boundary wall foundation.
Okay, thank
you. My client, the court found, and there's ample evidence in the record to support that if there were any damages, my client wasn't responsible for them with regard to the flooding problem. So I would ask the court to sustain the final judgment on count 1 and 3 as it relates to the involuntary dismissal granting of the motion, and on the facts as to counts 2 and 4 with regard to damages. Thank you.
Okay, thank you, counsel. All right, we'll give you
All right, a couple of things quickly. In the transcript on page 656 and 657, Salmon describes basically that he did survey the north line and that that is what determined the angles, not any angle off of any plat or drawing or anything else. And he did, so the question I guess comes as to what corners is there any kind of testimony about, what marks? All right, the real problem was that we were confronted with the Van Leer survey, which we couldn't cross-examine them. Nobody knows what they did or why they did it. But the only thing that, not even a survey, excuse me, just a drawing. Survey is what's done on the ground. So the drawing shows that they measure down 330 feet, which is what the plat calls for up in Crescent Beach, the plat to the north, and they set points on what they put as the south line of the condo, ultimately would be the condo property, I guess. But they set those points. And in the Beckman case, those are new points. They can't set new points to determine the line. That's what apparently Mercer buzzed up, and that's apparently what Tommy Sutton, who apparently did the field work, Mr. Putz didn't do any of it. He didn't go out and look for those or anything else. Now, mind you, that if they found the points as the drawing that Mr. Putz did to be there, and if the footer of the seawall, footer of the wall, the 6-foot wall, goes 2 inches, 3 inches, 4 inches, varies over the line, it's over those points. They're gone. Now, Salmon had points delineating the north line. If the court rules in favor of what Salmon found to be the north line, then the points are already set forth in the survey. It didn't have to go out. Now, as I point out in my reply brief, the survey that was done after the trial varies. The December 2nd, 1999 survey, or drawing by Putz, and let me just point out real quickly, the field work done by Sutton wasn't done until after that drawing was drawn. So all Putz really did was just retrace Van Leer. We don't know why. Anyway, that showed the Williams seawall being about a half a foot north of the Putz line. The survey that they did attaching it to the judgment shows that the bulkhead is 1.8 feet north of the line. It varies. And it takes more of her property than there was any testimony about. So, what
Mr. Olson said in his argument that basically the judge ruled, said here's the line, and then Mr. Putz went out after the fact and did a monument survey and put monuments down that basically are consistent with the judge's oral ruling, and that you were aware of that because they sent the proposed judgment. Is he incorrect about what happened there?
I don't think that the second survey was following the judge's ruling, which was based on the, he said, I can't tell you why, I don't know, but.
Oh, but in terms of just timing, the timing is the judge made his oral pronouncements that I find Putz got the line right.
In his 1999 survey, yes.
What's that?
In his December 2nd, 1999 drawing.
Right, so that he makes that pronouncement, then River Bend has Putz go out there and put monuments theoretically, supposedly along Putz's 1999 line.
Yes, sir, and like I point out, they're not.
Well, did you ever raise that to opposing counsel or to the trial judge?
Well, again,
Yes, or it's a yes or no.
that's a no. The judge had made his decision, he'd made his announcements. I didn't see any chance of getting anywhere with a rehearing, and so at that point we knew we were going to appeal, and so.
One of your arguments is that judges relying on documents that was not in evidence, and their position is no. He'd already said this is what the judge said this is what the line is, and all Putz went out and did was saying, okay, Judge, now that you've told me that this is what you agree, I'm going to put monuments out there, and I'm going to give you a piece of paper. I'm going to give a piece of paper about what I've just did post-oral pronouncement, which should, if I understand their argument, that should be consistent with what the judge said is the line, and you're telling us now that what he did post-trial, Putz, is not consistent with what the judge said.
On its face.
On its face.
Yes, sir.
But then you didn't say, hey, wait a minute, I get what you're doing, Putz, but you still got it wrong. That's not what the judge said. You didn't do that. You said you're going to just appeal it and not give the judge a chance to correct that, I guess, clerical error, for lack of a better word.
I don't know that it's a clerical error. We disagreed with so much of what the judge did that you didn't see any future in it. Yes, sir.
If Putz had put the monuments on the 1999 Putz line, would you have any complaint? I mean, so here's the final judgment, and you still think Salmon's right and Putz is wrong, but okay, so you rule with Putz. What Putz has done post-judgment, post-announcement of the judgment, if he had put those markers in the right place, would you care that he did it afterwards and submitted the paperwork afterwards?
Well, I still think it's improper for the court to incorporate a drawing that didn't even exist and survey groundwork that
Which is why you
was
tell
no
the judge
testified
this
to.
is not cricket instead of telling us, so he can go, okay, I hear what you're saying, let's do this a different way? Or tell us if you have problems with it, or?
Well, I mean, we had problems with it, yes, sir. We had problems with all the rulings, and but remember, the monuments the new points that Van Leer set were now under the footer.
Okay. All right, well, your time, if you want to just wrap up, your time's up.
Again, the only surveyor that testified that did any work on the ground, that actually did a survey was Salmon. He followed the rules. He did what a surveyor is supposed to do. He determined the corners to be obliterated. You're not supposed to determine corners to be lost. Putz didn't even render an opinion. He said, I don't know whether they're lost or obliterated or whatever. But he followed the procedure, and he reestablished the corners as obliterated corners based upon reliable testimony, which is what Barber Investments versus Walker's is all about in other cases, and he followed the proper procedure. It's the only evidence of a survey that was in this case.
Okay.
Everything else is just a drawing.
All right,
and
thank you,
hearsay.
counsel. Okay, we will stand adjourned. Thank you very much.